International Law, Chapter 5, State Sovereignty and Jurisdiction. What is state sovereignty? Sovereignty means the highest power possessed by state to make any decision over its territory. State is independent and free from outside control. The examples of sovereign states are Malaysia, Singapore, Thailand, and China. Characteristics of sovereign state: permanent population, government, relation with others, and defined territories.
Jurisdiction is an official power to make legal decisions and judgment. Concept of jurisdiction: Raja is a pregnant mother who is Thai and her husband Haziq is Malaysian. They are on vacation to Bangkok, Thailand. Arriving at Bangkok airport, Raja suddenly wants to give birth to her baby. Jurisdictions are required to determine the citizenship of the child. Extradition is an act where one jurisdiction delivers a person accused or convicted of committing a crime in another jurisdiction over to the law. Extraterritorial jurisdiction. Examples of situation: Ryan has killed Madam Maria in Malaysia, then he fled to Singapore. Does Malaysia have the right to enter Singapore territorial to bring Ryan back to Malaysia to be punished for his action?
Yes, Malaysia has the right to do so if Malaysia have an extradition agreement with the country involved, which is Singapore.
What is jurisdiction? Under international law, the jurisdiction concerns the intensity of the state to effect upon individuals, property, and conditions. It also mirrors the fundamental standards of state sovereignty, the balance of states and non-obstruction in domestic undertakings. What is the three types of jurisdiction based on international law? The three types of jurisdiction are legislative, executive, and judicial jurisdiction. What is mean by legislative? Legislative jurisdiction refers to the supremacy of the Constitution ally recognized organs of the state to make binding laws within its territory. For example, a state lays down the procedural techniques to be adopted by its various organs, such as courts, but can in no way seek to alter the way in which foreign courts operate. Secondly, executive jurisdiction relates to the capacity of the state to act within the borders of another state. For example, the unauthorized entry into a state of military forces of another state is clearly an offense under international law. Moreover, state cannot enforce its laws on foreign territory. For example, U.S. did not send its troops through Turkey to Iraq without the consent of the Turkish government. What is the significant meaning of judicial jurisdiction? Judicial jurisdiction concerns the power of the courts of a particular country to try cases in which a foreign factor is present. Yes. In criminal matters these range from the territorial principle to the universality principle, and in civil matters from the mere presence of the defendant in the country to the nationality and domicile principles. Jurisdiction divided into two significant parts, which is civil jurisdiction and criminal jurisdiction. What does civil jurisdiction mean? Civil jurisdiction: exercise of the civil jurisdiction has been asserted by states upon far more extensive grounds than has been the situation in criminal issues. Numerous nations, for example, the Netherlands, Denmark, and Sweden, will permit their courts to practice jurisdiction where the defendant in any activity has resources in the state, while in matrimonial cases the generally acknowledged ground for the exercise of jurisdiction is the domicile or residence of the party bringing the activity. What is meant by criminal jurisdiction? International law licenses state to practice jurisdiction regardless of whether by a method of legislation, judicial activity, or authorization upon various grounds. Yes. The significance of these jurisdictional standards is that they are acknowledged by all states and the worldwide network as being predictable with international law.
Principles of jurisdiction. The following are the types of principles of jurisdiction: the territorial principle, the nationality principle, and the passive personality principle. First, the territorial principle. This principle is a public international law that reflects one aspect of a sovereignty exercisable by a state in its territorial home. This means states have exclusive authority to deal with crime cases that happen within their territories. 6 individuals had been killed by British armed forces operating in Iraq. The applicants of this case were the relatives of the 6 Iraqi nationals who were killed by the British forces in Iraq in 2003. The applicants brought a claim against the Secretary of State because the judges refused to investigate the deaths and to provide redress to them. Their claim was dismissed on the 13th of June 2007 by the House of Lords. In dismissing the case, the House of Lords held that the crimes were committed outside the UK's territory, and therefore, the court did not have power to adjudicate. The second principle is the nationality principle. The nationality principle is a principle where it permits state to exercise its criminal jurisdiction over a person who have been a national at the time of the offences in another state. Thus, through this principle states are able to assert jurisdiction over their nationals even when they are abroad. Case that fall under the nationality principle is nationality decrees in Tunis and Morocco case where a dispute between Britain and France. Those states may prescribe the condition for the grant nationality, however when international law is involved it cannot be practiced especially when other states is involved. Generally, 2 most important principles upon which nationality is founded in states are: first by descent from parents who are national which is also known as jus sanguinis, and second by virtues of being born within the territory of the state which is jus soli. The third principle are the passive personality principle. This principle allows states to claim jurisdiction to try an individual for offences committed abroad which have affected or will affect nationals of the states. Eel was a citizen of St. Vincent and the Grenadines who was employed on a cruise ship departing from and returning to an American port. However, he was accused of a sexual conduct with a minor, a 12-year-old girl who happened to be a U.S. citizen where the crime took place in Mexican territorial waters. Special maritime and territorial jurisdiction of the United States with extent permitted by international law including any foreign vessel during a voyage. This means the sexual contact between Neil and the victim occurred on a foreign vessel that departed and arrived in the United States and the victim was a United States national. This conduct thus falls squarely under the definition of special maritime and territorial jurisdiction.
Principles of jurisdiction. The protective principle, and the universality principle. The protective principle. What is? It is unequivocally accepted that every country is competent to take any measures that are compatible with the law of nations in order to safeguard its national security interest. Every country has jurisdiction over behavior that adversely affects its national security, even if the conduct occurred outside that country. The Protective Principle Case, 1946. Joyce v. Director of Public Prosecutions. Born in America, fraudulently acquired British passport, in 1939 started working for German radio and claimed to have acquired German nationality, held himself out to be a British subject and had availed himself of the protection of a British passport, accordingly owed allegiance to the Crown. The universality principle. What is about? In its broad sense, implies that a state can claim jurisdiction over certain crimes committed by any person anywhere in the world, without any required connection to territory, nationality, or special state interest. The Universality Principle Case. Rwandan genocide of 1994, members of the Hutu ethnic majority in the East Central African nation of Rwanda murdered as many as 800,000 people, mostly of the Tutsi minority. Started by Hutu nationalists in the capital of Kigali, the genocide spread throughout the country with shocking speed and brutality, as ordinary citizens were incited by local officials in the Hutu power government to take up arms against their neighbors.
Conclusion. In a nutshell, sovereignty is the significant power of the state to make any decision independently over territory. While jurisdiction is surely the focal component of state sovereignty, for it is an activity of the power that may make or end legitimate relationships and commitments. Thank you.